When historians look back at this period, they may not describe it as a routine presidency. They may call it a constitutional stress test. Because in the first year of President Trump's second term, the question hasn't simply been political. It has been structural. How far does executive power truly extend under the Constitution of the United States? Let's be clear at the outset. This discussion is not about prior indictments, earlier investigations, or political narratives from the past. This is about what unfolded during the first year of his second term, examined chronologically and legally. And one important clarification, in light of recent Supreme Court rulings expanding presidential immunity for official acts, this overview focuses on actions that were alleged to be unlawful or unconstitutional at the time they occurred, regardless of how courts may ultimately rule. January 17, 2025, Financial conflict concerns. Just days before inauguration, rather than divesting from existing business interests, the president launched a new venture tied to cryptocurrency and digital assets. Critics argued that this structure created potential avenues for undisclosed financial influence, particularly if domestic or foreign actors sought political access through investment. Ethics experts raised concerns regarding transparency, disclosure obligations, and possible foreign influence risks. While not automatically unlawful, the situation prompted immediate debate about conflict of interest norms and the emoluments clauses. January 20th, executive orders begin. On the first day in office, a series of executive orders were issued. It is critical to remember, executive orders are not laws. They are directives to federal agencies, and they must remain within the scope of Article 2 authority and existing statutory limits. Among the most controversial directives, an attempt to restrict birthright citizenship by executive order, raising direct constitutional questions under the 14th Amendment. Suspension or modification of certain asylum procedures under emergency authority. Withdrawal from international organizations and agreements. Expanded immigration enforcement framed as national security policy. Reclassification of certain federal employment protections. Broad clemency grants, including in politically sensitive cases. Some of these actions, such as pardons, fall squarely within constitutional authority. Others triggered immediate litigation over separation of powers, due process protections, and statutory interpretation. Immigration and emergency powers. Throughout January and February, additional actions included emergency declarations tied to border enforcement. Freezing or redirecting congressionally appropriated funds. Expansion of detention operations. Use of National Guard or military resources in immigration contexts. These measures raised legal debates under the Posse Comitatus Act, the Take Care Clause, and the Impoundment Control Act. As is often the case in constitutional disputes, federal courts became the central battleground. Federal workforce and agency authority. Multiple inspectors general were removed. Civil service protections were altered. Officials within independent agencies were replaced or dismissed. The legal question here was not political, it was structural. Does executive authority extend to reshaping independent oversight mechanisms without congressional authorization? Litigation followed, particularly where removals were alleged to be retaliatory. Tariffs and trade authority. Beginning in early February, tariffs were imposed and adjusted under delegated economic emergency statutes. Supporters argued these actions were lawful exercises of congressionally delegated authority. Critics contended that certain measures exceeded statutory limits or conflicted with existing trade agreements. Once again, courts were asked to interpret the scope of delegated executive power. Universities, federal funding, and the First Amendment. Throughout the spring, federal funding was conditioned on compliance with specific administrative policy directives involving diversity initiatives, campus protests, and public institutional statements. Opponents argued that unconstitutional conditions were being attached to federal funds, potentially implicating First Amendment protections and spending clause limitations. Clemency and perception of favoritism. The Constitution grants the President broad clemency authority. Several high-profile pardons and commutations were issued. While constitutionally permissible, Critics argued that the pattern created the appearance of preferential treatment toward political allies, raising ethical, though not necessarily legal, concerns. Use of military force and war powers. Reports of targeted strikes and expanded enforcement operations abroad raised questions under the War Powers Resolution. The constitutional issue here centers on the balance between Article 2 Commander-in-Chief authority and Congress's Article 1 power to declare war. Media, press, and retaliation allegations. Clashes with media organizations led to allegations of viewpoint discrimination and retaliatory regulatory scrutiny. Lawsuits were filed invoking First Amendment protections and limits on executive retaliation. The Supreme Court context. Lower courts issued mixed rulings, some blocking executive actions, others upholding them. Meanwhile, the Supreme Court signaled increased deference to presidential authority in certain contexts, reshaping the legal landscape in real time. The larger constitutional question. Regardless of political affiliation, what we are witnessing is a constitutional pressure test. How far can emergency power stretch before it becomes overreach? What limits remain meaningfully enforceable? And perhaps most importantly, who ultimately draws those lines? The courts remain the final arbiters. But constitutional boundaries are often clarified only after conflict. Access to justice. All of this underscores an essential truth. The legal system is complex. Power is structured. And outcomes often depend on representation. For everyday citizens facing legal challenges, whether personal injury, civil disputes, employment matters, or government action, access to competent legal counsel is not a luxury. It is a safeguard. Because the Constitution does not enforce itself. It requires advocates.